Post-independence, this is perhaps the biggest overhaul of the Indian legal system that we are set to witness. The three bills that are proposed by the centre are set to take on the reformative process. Shedding off the colonial baggage is the need of the hour, says the union government, says the Modi government. The three bills are the Bharatiya Nyaya Sanhita bill, Bharatiya Sakshya Adhiniyam bill and the Bharatiya Nagrik Suraksha Sanhita bill. These particular laws are meant to replace the Indian Penal Code, Indian Evidence Act and the Code of Criminal Procedure. The committee headed by BJP MP Brijlal proposed several key changes to these bills. Subsequently, the centre reintroduced and revamped the criminal law and is all set to present it on the floor of the House. However, several recommendations have gone unconsidered by the committee. What exactly is going to change? Let's deal with them one by one. The Bharatiya Nyaya Sanhita 2023, this particular law replaces the Indian Penal Code. This new law will have about 356 sections. 175 sections have been changed. 8 new sections have been added and about 22 sections have been repealed. What does it mean? What does it do in substance? The IPC, it provides for protection from prosecution to a person of unsound mind. I'm going to give you certain examples about what kind of changes have been brought in. So the Indian Penal Code gives you protection if you're a person of unsound mind. The Bharatiya Nyaya Sanhita changes this particular terminology with mental illness. Now, the definition of mental illness excludes mental retardation and includes abuse like alcohol and drugs. While the individual suffering from mental retardation may be prosecuted, those who are voluntarily intoxicating themselves might find some relief in law. This particular point needs to be elaborated upon by the courts as and when it reads and reaches the courts for adjudication and for proper interpretation by the respective courts of law. Let's come to another facet. The definition of terrorism includes an act that intends to intimidate the public order. This may lead to breaches of peace at the local level being qualified as terrorism. It's a stringent definition that has been put in law. The Bharatiya Nyaya Sanhita, the proposed law, omits section 377 of the Indian Penal Code, which was read down by the Supreme Court. This removes rape of men and bestiality as offences as far as IPC is concerned or the Bharatiya Nyaya Sanhita is concerned. Offences against the body. The IPC criminalizes acts such as murder, abetment to suicide, assault and causing grievous hurt. The BNS retains these provisions. It adds new offences such as organized crime, terrorism, murder or grievous hurt by a group on certain grounds. There are sexual offences against women that continue to be included. The IPC had criminalized such acts such as rape, voyeurism, stalking, insulting women, outraging the modesty. The Bharatiya Nyaya Sanhita has retained all of these provisions. It increases the threshold for the victim to be classified as a major in the case of a gang rape from 16 to 18 years of age. It also criminalizes sexual intercourse with a woman by deceitful means or making false promises, something that has been the law of the land. Now let's come to the most important part and the much talked about part of the changes. Sedition. BNS removes the offence of sedition in its earlier form. It instead penalizes exciting or attempting secession or rebellion or subversive activities. The Bharatiya Nyaya Sanhita has made certain important changes as far as the offence of sedition is concerned. Union Home Minister is on record on the floor of the House to say that the offence of sedition will be done away with. Disaffection towards the government is something that will be permitted, and that particular terminology of the particular provision of sedition has been done away with, which was problematic, and that is why that particular law was put in abeyance by the Supreme Court of India. In fact, a far more elaborate section pertaining to offences against the state or the nation has been put in that particular chapter or in that particular provision that deals with these kind of offences that endanger the sovereignty or unity of India or promote certain activities that may be secessionist in nature. Talking about terrorism, the new law also defines terrorism as an act that intends to threaten the unity and integrity. There are far more broad definitions that have been put in place to ensure that any person indulging in such activities is taken to task. At the same time, the line that the law must draw is rather about ensuring that dissent is not classified as some form of sedition or a crime against the state. One more important change is about mob lynching. BNS has added murder or grievous hurt by 5 or more people on specified grounds as an offence. These grounds include race, caste, sex, language or personal belief. The punishment for such a murder is minimum of 7 years of imprisonment up to death. There are various rulings of the Supreme Court that had said that mob lynching should be made an offence. Briefly touching upon the Bharatiya Sakshi Bill of 2023, it replaces the Indian Evidence Act. It will have about 170 sections. 23 sections have been changed, 1 section has been added and 5 sections have been revealed. The Bharatiya Sakshi Bill 2023, it replaces the Indian Evidence Act. It will have about 170 sections. 23 sections have been changed. 1 new section has been added, 5 sections have been repealed. Now, the primary intent or changes as discussed appears to be to consolidate various aspects dealing with the evidence law into one portion, or to make sure that it's consolidated and organized in a proper manner. The new law pitches for uniform interpretation and application of similar standards. For example, the experts of electronic evidence are at par with other experts for determining relevant facts. The effect of certain provisions, particularly relating to confession, is still to be delved upon. The new law makes confession admissible in certain circumstances, leaving a broad discretion to the court to decide when exactly confessions can be made admissible. Let's come to the Bharatiya Nyaya Sanhita Bill. It shall replace the Criminal Procedure Code. The new law to have about 533 sections. 160 sections of the old law have been changed. 9 new sections have been added and 9 sections have been repealed. This law mandates forensic investigation for offences punishable with 7 years of imprisonment or more. Forensic experts will visit the crime scene to collect the evidence and record the process. All trials, inquiries and proceedings may be held in electronic mode, and communication devices that contain digital evidence will be allowed for investigation, inquiry or trial. If it's a proclaimed offender or somebody who's absconded to evade the due process of law, the trial can be conducted and the judgment can be pronounced in his absence. Along with specimen signatures or handwriting, finger impressions, voice samples, they may be collected for investigation or proceedings. So broad paradigms have been set as to the role forensic investigation is going to play. One of the more important facets of the new changes is that it also allows about 15 days of police custody, which can be authorized in parts during the trial. It also has a certain sense of danger, which is that 40 or 60 days or 60 or 90 days period of judicial custody. It may lead to denial of bail for long periods, especially if the police custody is taken into certain portions and not exhausted in one go. The crucial changes that have been presented by the government are set to overhaul the Indian legal system. Indeed, after independence, this is going to be one of the biggest changes that we are set to witness. Shedding of the colonial baggage, consolidating the world's longest running constitution and the broad provisions that we have under CRPC, IPC and various other provisions of the constitution to make it simpler and also amenable to the needs of today's country. That's the intent that the government says it has. Let's see to what extent they are successful in delivering the task that they have really taken upon themselves as they are set to make these changes.